Your Honor, my name is Matt Lawler and I am the fire investigator for the Monarch Fire Protection District. I am here today to present an argument as to why the evidence in this case should be admitted and shown to a jury. As you know, at 1:17, fire crews responded for a report of a residential structure fire at 614 Mays Street and found smoke showing from the eaves and vents of the home. After forcing a door to gain access, firefighters found a working structure fire in the living room. Crews used a hose line to mount an interior fire attack and successfully extinguished the fire, declaring it under control. Please note that when declaring a fire under control, firefighters may still need to perform searches of the entire structure, overhaul operations, and investigations before releasing the structure to the residents or board-up company. The homeowner arrived on the scene shortly thereafter and stated no one was in the building. While crews were cleaning up their equipment following extinguishment, another structure fire was reported with victims trapped 3 blocks away. The crews quickly loaded their hose and responded without securing the residents due to the urgency of the call. Although they needed to leave the scene unsecured, this was an appropriate decision considering the potential for loss of life. When I arrived on the scene, the homeowner was not present. Knowing that the crews had left the scene urgently, I felt it imperative that I enter the home to determine that the fire was fully overhauled and there was not a risk of a rekindle. I also needed to perform the fire investigation, as it would have been performed if crews had not left the scene on another emergency response. As you know, Your Honor, there is case law directly related to this. In the 1978 Supreme Court decision, Michigan v. Tyler, the court declared that the warrantless entry rights of firefighters to extinguish a fire do not end as soon as the flames are put out. It noted that firefighters may have to perform an investigation to prevent a rekindle to preserve evidence from accidental or intentional destruction. It also held that re-entry to the scene without a warrant was permissible if it was connected to the initial emergency. Courts have upheld searches and investigations without warrants as much as 11 hours after the initial emergency. A Connecticut court, in the case of State v. Wilson Bay, also decided that a search by an investigator was reasonable even though it went beyond the area of the origin of the fire. The fire department had conducted overhaul operations on the structure to check for fire extension, and the seized items were in plain view. Numerous other courts have also allowed evidence found during overhaul operations. The Supreme Court has also said that there is no specific formula for allowable time length of re-entry, and that each particular situation determines its reasonableness. The courts have generally given a wide latitude to firefighters and inspectors who behave in a reasonable manner. Since firefighters had left the building for another emergency, I felt it reasonable to continue the search of the structure. Your Honor, during my investigation, I discovered a type of melted device behind the TV in plain view at the origin of the fire. I also noticed what appeared to be a V-shaped burn pattern on the floor leading from the TV into the kitchen. Here is a photo of the V pattern. This type of pattern can typically be found when an accelerant is used to ignite a fire. Here is a diagram of the living room and the kitchen with the melted device and the V pattern indicated. Your Honor, our department is aware of the importance of the Fourth Amendment, and we routinely train our investigators on the legalities involved in performing our duties. But my entry into the building was clearly a continuation of the initial efforts of the firefighters who had left the scene under emergency conditions. Our department routinely checks the entire structure during overhaul operations to ensure the home is safe for re-entry. The evidence seized during my investigation was in plain view and viewed during these efforts to ensure the safety of the residents. Thank you for your consideration.